This podcast is sponsored by Murgitroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgitroyd.com/podcasts.
Welcome to the fourth season of Murgitroyd's Innovation Talks podcast. We're delighted you've joined us. If you have any questions, you can email us at innovation.talks@murgitroyd.com or via @Murgitroyd on Twitter. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's podcast.
Hi, I'm Terry Devlin. I'm a European patent attorney in the Aberdeen office of Murgitroyd. And today I have the pleasure of the company of James Brown.
Hi there.
James is our lead patent attorney in the Aberdeen office, and we will be talking about trade secrets. James, can you tell us what the main difference between trade secrets and other forms of IP are?
Sure. So trade secrets, the clue's kind of in the name, in that trade secrets are the secret sauce, as it were, of organizations, companies, individuals. And they're something that if you can keep them back, keep them secret, then they can be very valuable to the company or organization. So think of, for example, the Coca-Cola recipe or the Iron Brew recipe. Those specific recipes are very, very valuable to those companies. And back 100, 150 years ago, for example, Coca-Cola would have had the option, possibly, of filing a patent application to protect that recipe. And for them, that would have given them 17 or 20 years protection for that recipe. But it would have the big disadvantage to them that it would cause them to publish that recipe in the patent application when the patent application is published. So yes, they may have a 20 years protection while they had the patent in force, but once that 20 years is up, anybody can basically make the carbonated soft drink to that recipe simply by reading the patent and following the recipe. So certain things can definitely be best protected by keeping them as a trade secret.
So on one hand, a patent would cause you to fully disclose the recipe or the secret, whereas keeping it as a trade secret keeps it away from public and competitor consumption. So I can see that is a very appropriate way in many instances to proceed.
No, I agree. Taking, for example, a patent, for certain inventions, patents are crucial. But if you want to obtain a patent for an invention, you need to describe in very minute detail how the invention works. And doing that, yes, it'll obtain you the monopoly granted to you by the government, assuming that the patent is granted. And that monopoly can last for a relatively long time of up to 20 years. But once that 20 years is up, anybody can obtain access to the information and, well, not only obtain access to information, but more importantly, anybody can work the patent, can read the detail in the patent and can start manufacturing the product, for example. So there's definitely a tension between whether to keep a particular product or invention as a trade secret or whether to, for example, file a patent application for it.
So if you think that your product could be reversed engineered, or there was a risk that it could be reversed engineered, it therefore wouldn't remain secret. And perhaps in that case, seeking patent protection would be the most appropriate way to proceed.
Yeah, I think that's absolutely the key question to ask with a client right at the outset. And so with each and every innovation, new thing that a client's come up with, a new invention that a client's come up with, I think the first question to ask is this new invention, something that can be readily back engineered when the product is launched? Because if it is, then I think that pushes you much more to consider patent protection for the invention. Whereas if it's not something that can be readily back engineered, then that is something that will push you towards the trade secrets form of protection for the invention. So, for example, Google have built up many, many years now of R&D into the algorithms that they use in their search engine. They may well, particularly in the US, it may well have been possible for them to file a whole series of patent applications for the algorithms and how they work, etc. But the vast majority, it's far more beneficial to them to keep them as trade secrets rather than to publish them in patent applications, because it's very difficult for competitors to back engineer, to reverse engineer. how the algorithms are structured. So that's another example of an innovation that is probably best kept as trade secret.
That's very interesting. It seems that in our day-to-day lives, we are probably encountering using lots of products which actually have trade secrets within them.
Absolutely. And even a lot of manufactured goods, it may be that it's the manufacturing process that is the new thing that allows, say, the product to be made more quickly, more efficiently, at lower cost, use lower materials, for example. And it may be difficult, if not, it may not actually be wise to try and patent that, but instead it may be better to keep that manufacturing process as a trade secret, for example. And so we've worked with clients in the past to, for example, if there's one key stage in the manufacturing process, then, for example, to physically wall that off in the factory, and to have special security for any personnel that are going into that section of the factory line. Literally, people have to sign in, sign out. There's an enhanced confidentiality agreement required that physically has to be signed by specifically authorized individuals that are allowed to go into that special part of the manufacturing line. So the most important thing, if you are looking at keeping your innovations protected by trade secrets, is to actually put some security in place. Whether that's the recipe for Iron Brew, apparently only the two brothers of the bar company know the actual recipe, and it is literally kept under lock and key in a safe. Or whether it's your customer lists, your price lists, to keep them confidential in the company, ensure that all employees that are employed by the company are signing up to a specific list of what is to be kept as a trade secret in, for example, a company manual. That there's actually a list of what the company considers as the secret sauce, as it were, what the company considers as trade secrets of that company. And that way, if you put in specific protection mechanisms, if, for example, a disgruntled employee leaves and, for example, takes your client list, your price list, as long as you've got the mechanisms in place, you can enforce your trade secret rights through the courts, for example, and get physical seizure of the company information that's walked out the door.
It's very interesting. So it would seem that it's highly critical that persons who have access to trade secrets are contractually bound not to disclose the information.
Absolutely.
Quite a few clients that come to me with inquiries are often quite savvy about keeping their IP confidential, to the extent that they would be asking me to sign confidentiality agreements to maintain secrecy over what they're going to tell us. Have you experienced that yourself, and do you have any thoughts on how we should approach it?
Yeah, no, it does happen from time to time. A client will ask us to sign a confidentiality agreement. As chartered patent attorneys, we're actually bound by our chartered institute and by the IP regulation board to keep all client information confidential, and we're also covered by privilege, which in a similar manner to solicitors means that nobody else can gain access to our records, our files, through, for example, if they try to apply for a court order, they wouldn't be allowed. So from our point of view, we don't need to sign confidentiality agreements with clients. However, confidentiality agreements, non-disclosure agreements are absolutely critical to clients if they need to discuss their trade secrets, for example, or new inventions with somebody who isn't bound by confidentiality to them. So type of individuals or organizations who would be bound to keep a client information confidential would be patent attorneys, lawyers, solicitors, bank, for example. However, if they're looking to go and speak to a potential customer or an outside consultancy, engineering consultancy, for example, then those sort of discussions, on the face of them, unless something is agreed otherwise, are probably not going to be held as confidential. So in those sort of situations, it is really important, critical for the client to have a specific confidentiality agreement, or sometimes called non-disclosure agreements, signed and agreed by the other party.
That's very interesting. Thank you very much, James, for that valuable insight.
Thank you very much, Terry. Pleasure.
Thanks for your time today. We hope you found today's podcast valuable. And remember to subscribe so you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgitroyd.com.